Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 151. Thank you for the comments that came in on the relaunch of the podcast. They were much appreciated. As ever, get in touch if you have any comments on the new formatting and so on, because it's obviously something that is important to us. I enjoy doing them, but it's also important that people enjoy listening to them. Anyway, 3 cases this week cover the issue of what can amount to gross negligence, sufficient negligence to dismiss an employee. We have got one on restricted reporting orders and whether the need to protect the alleged perpetrators of the offensive actions could justify a restricted reporting order, and a case on whether a discretionary bonus had become contractual. I'm conscious this podcast is a week or so late in going out, for which many apologies. I did a special podcast for the Employment Lawyers Association, which is an interview with the President of the Employment Appeal Tribunal, and that should be coming out probably the next couple of weeks on the Employment Lawyers Association website, but I will do a special one-off to tell people when that's coming out. It's well worth a listen to, because he was a really interesting guest and had a lot to say. Okay, let's start. Ardron and Sussex Partnership NHS Foundation Trust. The facts of this case are both sad and fairly specialist, but I think they've got a wider impact. The claimant was employed as a consultant psychiatrist by the Trust. She was working partly at a prison, and at the prison a young prisoner tried to commit suicide but was successfully resuscitated. The claimant saw him after the suicide attempt and made a medical diagnosis for him, but it is alleged that culpably she didn't prescribe any medication for him. It's alleged there were also failures of record keeping by her and a number of other alleged failings. And tragically, 3 months after his initial attempt, the prisoner's further attempt suicide was successful. After investigation, the Trust started disciplinary proceedings against the claimant. The disciplinary letter stated that the claimant's behaviour could constitute willful and gross negligence, could be a breach of trust and confidence, and that the outcome of the proceedings could be the dismissal of the claimant. The claimant applied for and was granted an interim injunction restraining the Trust from going ahead with the disciplinary charges because, she asserted, there was no basis for saying that her behaviour amounted to gross negligence or willful misconduct. That, as I say, raises particular issues because of the way the disciplinary process is constructed in the NHS. Applications for injunctions to restrain disciplinary proceedings are not unheard of in the NHS because of the way the policy is set up, but it's not something that I've seen mirrored in private practice. The interim injunction lasted until the full trial, and the High Court then, when it came to deciding the matter at the full trial, declined to confirm the injunction. This is where I think the case has wider applications for employers generally. The issue was whether or not it was appropriate for the employer to proceed with the disciplinary process. Clearly, in this case, the claimant's remedy was seeking an injunction. Equally, in other cases, it may be for the employee to assert constructive dismissal and resign and claim damages for unfair dismissal and breach of contract, amongst other things. So the issue of whether or not the employer was entitled to go ahead with the disciplinary proceedings is the wider issue. First of all, the High Court said here that the question as to whether or not it is a breach of contract for an employer to pursue a case of gross negligence against an individual is to look at the facts, the evidence, the assertions, and see whether combined they are capable, when taken at their highest, of amounting to gross negligence. Secondly, the fact that the employee may be guilty of gross negligence but have mitigating evidence doesn't mean it's wrong to refer matters to the disciplinary panel. That should sort out whether the evidence is truly mitigating or not. Similarly, if there are significant issues of fact that are highly contested, as I think there were here, again, the court said, the appropriate place to sort that out is the disciplinary panel. Here, the court said on the facts there was no doubt there was a potential claim of gross negligence against the claimant. Now, this is my other reason for wanting to mention the case. Gross negligence cases are relatively rare in practice. The example that is always given is of the airline pilot who negligently lands his plane. By good fortune, no one is injured, and there is no damage, but the employer cannot possibly take the risk the pilot would act similarly negligently again, and therefore the pilot is dismissed. Obviously, that's an extreme and pretty unusual set of facts. Here, we have potential failings over a 3-month period in relation to a prisoner who tried to commit suicide and subsequently succeeded. The failures included failure to prescribe medication despite the diagnosis of psychotic illness, and record-keeping failures and other related failures. So when put together, this was capable, I emphasise, of amounting to a case of gross negligence. On that basis, for the Trust to go ahead with the disciplinary proceedings against the claimant for gross negligence was not a breach of contract. But pausing here for a moment, we have a possible set of facts which are far more likely to arise in a commercial environment which establish a potential gross negligence case. So you have an example that, if you look at it that way, is going to have far more common application than the airline pilot example. Similarly, the Trust disciplinary letter also referred to a breach by the claimant of the implied term of mutual trust and confidence. This is something we've seen a bit of recently, with employers looking to run arguments to say that the duty of mutual trust and confidence works both ways. Of course, we see it most often with employees resigning and claiming that the employer has acted in what is effectively a manifestly unreasonable fashion. Here it's the employer asserting that the individual has acted in a manifestly unreasonable fashion, and that amounts to a breach of contract by the individual. Again, court accepted this disciplinary charge was open to the Trust. Now remember, of course, that none of these allegations have actually been determined as yet, so this case is simply about whether there is a sufficient case to proceed. But the court did say that the arguments on mutual trust and confidence were essentially the same arguments as the ones on gross negligence. Pausing there, I don't think, by the way, this means that for the employer to say there has been a breach by the employee of the duty of mutual trust and confidence, there has to be gross negligence. I think it is simply the court saying, in this case, that the factors that amounted to gross negligence, potentially, also justify proceeding on a charge of breach of the duty of mutual trust and confidence by the individual. The Trust had also asserted in its disciplinary action that the claimant was acting willfully in her underperformance. The court said it had considerable doubts about whether that would be shown, as it was far more likely that she was being negligent rather than willful. But even there, the court said that there was a case that could go forward to the disciplinary panel. So, overall, although it relates to the rather specialist world of NHS disciplinary proceedings, I think there are general lessons here for employers. The court is giving quite strong support to employers to determine, through a disciplinary process, allegations of misconduct or negligence. Do the allegations at their highest justify the disciplinary action which has potentially been flagged up? The formulation of the case as meeting the test for gross negligence is rather more real world than the airline pilot example which has previously tended to be trotted out. And further, as an illustration of the duty of mutual trust and confidence term going both ways, this is something which can be used against an employee in cases of underperformance or negligence, as well as against the employer. So, that's the case of Ardron and Sussex Partnership NHS Foundation Trust. Next up, A&B and X, Y and the Times Newspapers Limited. This is a case that was decided back in July last year, which was only published in April this year. It deals with an application for a restricted reporting order and an anonymity order. Indeed, it's possible we've referred to this case in principle in a couple of podcasts we did during the course of last year on the subject of restricted reporting and anonymity. However, now that we've got the full judgment, I did want to just take a look at this case because I think it's quite interesting. Partly for the arguments that the case rejects, as well as for the decision it actually comes to. Let's deal with the factual background first. Obviously, at the time this case was on its way through the system, there were allegations, but no actual facts found. The claimants were employed by the first respondent, which is a company. They claim that the second respondent, an individual, had been guilty of sexual harassment to them and that sexual offences had been committed. These allegations are completely denied. The claimant's identity was automatically protected under the Sexual Offences Amendment Act 1992, but the respondents sought restricted reporting orders and also anonymity orders. In essence, the restricted reporting orders last until the outcome of the case is announced, but anonymity orders can continue beyond that date. The Employment Tribunal granted a restricted reporting order. The judge said this was to continue until the day after the remedy hearing. Since the tribunal was due to be held in 2 stages, a liability hearing followed sometime after, by a remedies hearing. This had the effect of extending the timetable of the restricted reporting order. The tribunal judge refused to grant the anonymity orders, and the claimant in the Times newspapers appealed. As we've previously seen, the law relating to the grant of an anonymity order, or a restricted reporting order, is covered by Rule 50 of the Employment Tribunal Regulations 2013. Tribunals can make an order to prevent or restrict public disclosure of any aspect of tribunal proceedings if the tribunal considers it, quote, necessary in the interests of justice in order to protect the convention rights of any person," unquote. The tribunal has to give, quote, "full weight," unquote, to the principle of open justice and the convention right to freedom of expression. The second respondent, the individual, applied for anonymity and restricted reporting orders on the grounds that it was necessary to protect his rights under Article 8 of the European Convention of Human Rights, which is the right to privacy. The company, the employer, could not itself apply for a restricted reporting order covering itself because they can only be made in favour of individuals. But it was accepted by all parties that it would effectively be covered by the restricted reporting order made for the second respondent, because if the company's name was published, that would lead to the potential identification of the second respondent. So obviously the second respondent and the company are synonymous in this in the factual scenario here. Both parties agreed that the decision of the court involved a balancing exercise, in particular between the right to freedom of expression and the principle of open justice on one side, and the right to privacy. The tribunal judge granted a restricted reporting order in favour of the second respondent, the alleged perpetrator, and she made a number of statements. First of all, she pointed out that the 1992 Act, which automatically gave the claimants protection, meant that there was a disparity as between the claimant, accusers, and the second respondent, the alleged harasser. One side had automatically had anonymity, restricted reporting, and the other did not. The judge said this was not workable here to have a restricted reporting order in respect of one side only. Partly this was because the claimant's protection under the 1992 Act would probably require some degree of redacting identifying material, and so partly in order to ensure that the restricted reporting order in favour of the claimants worked, the tribunal said the respondents should have the same. The tribunal judge decided that the restricting reporting order was to remain in place until after the remedy decision rather than after the end of the liability decision, and she said this was to allow time for the parties to make submissions about making anonymity orders to last after the end of the case, once the outcome of the liability hearing was known. The Times newspaper and the claimants appealed against this decision, and the key points to come out of the EAT decision was it is not relevant whether or not there was parity between the claimant and the individual respondents. The 1992 Act was a decision by Parliament to give protection to the alleged victims of sexual offences, but not to extend such protection to alleged harassers. The EAT accepted that an alleged harasser, here the second respondent, could have interests that should be taken into account by the tribunal in deciding whether or not to make a restricted reporting order to protect a party's qualified right to privacy. There was some support from this from Hansard, the Parliamentary Journal, where the relevant legislation was being debated, where the government minister said that it was intended to apply to protect those who were falsely accused of harassment as well as the alleged victims. Although the court pointed out it was difficult here to know when someone is falsely accused until after the trial has taken place, this was support for the idea that the harasser's interests could be taken into account as well in deciding whether to grant a restricted reporting order to allow matters to be determined. The tribunal judge here was felt not to have given sufficient weight to the principle of open justice, because the ability of the press to report legal proceedings was an inseparable part of open justice. It was not enough by itself to have the case heard in public if it could not be reported publicly. However, the tribunal did not have to assume that unproven allegations of sexual offences against the second respondent, if publicly reported, would not cause undue distress and damage. Nor did the tribunal have to assume, in deciding whether or not to grant a restricted reporting order, that the public would understand the difference between allegations of harassment and proof of harassment. It was also relevant that a restricted reporting order would avoid the danger of unsubstantiated allegations being spread widely, without hushing up the consideration of the important underlying issue of the claim itself. Secondly, it was relevant to the decision to grant the restricted reporting order. The allegations were shocking, they were serious, they were about sexual activity, which is of course at the heart of anyone's private life. Finally, the principle of innocent until proved guilty meant, with a restricted reporting order, neither side would worry about allegations being publicly discussed and speculated on until after the tribunal had made a decision. All of these factors were potentially relevant to the grant of the restricted reporting order. However, the EAT went on to decide that the restricted reporting order could not continue until the remedy hearing. It had to end at the end of the liability hearing. It wasn't permissible to continue it, which meant that the restricted reporting order, if granted, would have a shorter lifespan. At the end of the day, the matter was sent back to a different tribunal to carry out the balancing exercise, presumably paying full attention to the principle of open justice, to consider afresh whether a restricted reporting order should be made. Well, the reason I wanted to go through all this is that, as we've said a number of times in this podcast, restricted reporting orders and anonymity orders are extremely important. Here we have a clear decision from the EAT that an alleged harasser may ask for their interests and rights to privacy to be taken into account, and they can do that, and the tribunal can take that into account. However, it does seem to me the courts will obviously continue to give fairly heavy weight to the principle of open justice, which means allowing the press to report hearings, unless a tribunal judge is convinced it's necessary to make a restricted reporting order. The point that might resonate with the man or woman in the street, namely that there should be equal treatment between the parties, it's not a factor at all. Claimants have rights under the Sexual Offences Act 1992, harassers do not, and that's that. So that's the case of A and B, and XY and the Times Newspapers Limited. Third and final case, Bluestones Medical Recruitment Limited and Swinnerton. This case relates to a situation which arises frequently, particularly on the termination of senior executives partway through a financial year. The issue is determining whether a discretionary bonus scheme has become contractual by means of custom and practice, and in the case of a senior executive going, whether that means that they can claim a bonus even though they're not going to be around at the end of the year when bonuses are handed out. In this case, and I'm going to simplify the facts a little because I'm not going to go through all aspects of the case, the claimant worked for Bluestones as their medical manager. His contract of employment very clearly stated that the bonus was a discretionary one. The bonus would be of such amount and such intervals and subject to such conditions as the company may in its absolute discretion determine from time to time. Pretty comprehensive. When the individual was being promoted within the company, there was some discussion about him becoming a shareholder and being paid a dividend, 6.5%. In the meantime, since he was not a shareholder, there was some discussion there was going to be a discretionary bonus paid to him, which would then be repayable against dividends. The employer's case was that this discussion did not change the fundamental deal with the individual, i.e. the bonus remained discretionary. Claimant was then dismissed for gross misconduct, and at the date of his dismissal, the bonus that was due to him was outstanding. The Employment Tribunal decided this amounted to an unauthorised deduction from wages contrary to Section 27 of the Employment Rights Act 1996. The Employment Tribunal had said that by virtue of custom and practice, the bonus scheme had become contractual. The claimant was entitled to receive the bonus. Its failure to do so was a deduction from wages. Therefore, the claimant won. The company appealed to the EAT. The EAT accepted that the onus was on the claimant to demonstrate the legal entitlement to the payment that was unlawfully deducted. The claim had to be in respect of an identifiable sum. Therefore, the first question for the EAT and for the Employment Tribunal had been to determine what was the contractual term that established the bonus was due to the claimant. Where's the contract? Here, the EAT said that the Employment Tribunal had failed to make sufficient findings of fact. The EAT referred to a case which had considered whether a discretionary redundancy payment scheme had become a contractual redundancy scheme. It's a case called Park Cakes Limited and Shumba. In that earlier case, the court had identified a number of factors a tribunal could look at in deciding whether a redundancy scheme had become contractual. This included, for example, the number of occasions that payments had been made under the scheme, over how long had the scheme allegedly been in operation, were the payments always the same, i.e. calculated according to the same formula, or did they vary from time to time? Were the benefits of the scheme generally publicised, and how were the terms of the redundancy scheme described? What did the express contract say? Was the evidence of the payments being made indicative of a contractual entitlement, or was it equally capable of being explained by the employer exercising its discretion on each occasion that the redundancy payment was made? Applying that here, you can easily see how those factors could be applied to the existence of a discretionary bonus scheme versus a contractual bonus scheme. The EAT decided the matter had to go back to a new tribunal to try again. Although the contract of employment had said throughout that the bonus was discretionary, it was possible that the tribunal could find here, the EAT said, there had been an express contractual arrangement agreed when the claimant was promoted, which converted the payment into a contractual entitlement at that stage. As I said at the start of this section, it's hardly unusual to find an employee claiming an entitlement to a bonus which the employer claims is discretionary. Here, the court has provided useful reference to the sort of factors that a tribunal could take into account in deciding whether or not a bonus has become contractual by virtue of custom and practice. But the EAT itself has pointed out there may be another route. There may be evidence of a verbal agreement between the parties during the lifetime of the contract, which has the effect of converting the bonus from a non-contractual one into a contractual one. So, that's the case of Bluestones Medical Recruitment Limited and Swinnerton. Only remains for me to say thank you very much indeed for listening to the podcast. Do get in touch if you have any thoughts, comments, questions, etc., etc. As always, I think it only remains for me to confirm that no employees were harmed or mistreated in the making of this podcast. Thanks very much for listening.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.